What up, everybody? How are you? Okay, I'm in the room, and they're making a big stink that any recording or court proceeding held by video or teleconference is strictly prohibited. So I'm trying to figure out what to do with this situation. I could give you a play-by-play. Like, I'm listening to them now. Nothing's happening yet. It's not starting for another 8 minutes. But they got a big sign up saying any recording is strictly prohibited, which is stupid, insane, asinine. I could repeat what's being said. That wouldn't be a problem. Yeah, it's funny because you're in two different chats. This one is in YouTube, and this one is in, I'm sorry, this one's in Rumble, and this one's in YouTube. And you're all saying the same thing. And I agree with you. It's totted. It doesn't make any sense. It's the stupidest thing in the world. I'll show you temporarily since there's nothing happening now. But yeah, I don't think I'm going to lose my law license over this. Meaning, I don't want to risk losing my law license over this. They even have like an audio thing saying any recording of this is strictly prohibited. Now, if this was state court, I would be less bothered by it. I think federal court probably has jurisdiction over me now. I'm trying to decide federal court in Northern District, California that I'm not admitted into. They have this jurisdiction over me. I'm walking a very fine line. You don't have any audio. I didn't give you any audio. Do any of you know something I can have which would generate closed caption of what I'm hearing as I'm hearing it? Is there a program I can do where that way you would have the closed caption of what's coming out? Like it would be some sort of interpretation? I'm looking to you for help here. So speak up. I'm watching the chat very... You cannot hear the audio. I have this in here. You cannot hear the audio, but I can't even show you the video. But there has to be some... Okay. I'm doing a quick check. I'll pay for it right now if I have to. Generate closed captions. Live video. Generate subtitles. I'm using Chrome. I don't think they mean that. And they're talking about of a live video, not of this. I usually play it through StreamYard, and I would just, and it's a live thing that I would just show you. It's starting in 4 minutes. Using Latin legal terms poorly, but so what should I do? Do you have... I think streaming is considered recording because it automatically gets saved. Remember I told you the extension post a long time. You don't click on the policy piece, you can search for additional extensions for Google Chrome. Let me see. I have it here. Volume booster, volume return to YouTube. Dislike YouTube volume booster. That's just volume stuff. Manage extensions, sheet stock slides, volume booster. I found this thing V. That's not working. See, these things I'm seeing which provide. You select one of the following options. Caption. Yeah, I don't think that's going to be considered complying. Yeah, I think what I'm going to do is I'm just going to. Best I can do is I'm just going to just repeat what's being said as it's said to the best of my ability. It's going to be tricky, though. It's going to be very tricky. We're going to try this out. You're not going to see it and you're not going to hear it. I'm just going to repeat what's being said as it's being said. And this way, it's my own words. Type in closed caption, manage extension, search the close. No, I don't have it. It's a caption. There's nothing there. It's good thought, Anthony, but it's not there. It's not a link, it's a Zoom, and they only let 1,000 people in. And I'm very nervous that if I fall out, I'm not going to get back in. I don't know how to. I'm trying to remember where I found it. Oh, I can give you. I can give you the link where I found it. Here's the link where you click a thing. Control. I'm not going to click it myself, but I'll give you the link that I clicked. I'll put this in here where you can click it. So if any of you, if there are spots available and you want to jump in there, that you'll be able to do that. I'm going to put that in locals. You all race to locals. Link to Zoom of oral argument. All rise. Charles Breyer presiding. You may be seated. Recording in progress. Calling civil action CV 25-4800, Newsom et al. Versus Trump et al. Counsel, please step forward and state your appearances for the record. Nicholas Green from the Office of the Attorney General on behalf of Governor Newsom and the state of California. With me at council table today are my colleagues Nicholas Spiritu, Megan Richards, Megan Strong, Michael Mangin, and Samuel Harbert. And on the Zoom, we have my colleagues Laura Fair and Melissa Maloof. Okay. That's the judge. I couldn't hear what he said. Chris Edelman, I couldn't hear who the lead for the Trump was. Let me make some preliminary comments. This is the judge talking before we get underway. Judge now. As you know, the court has entered an order. In this case, initially, the only order which was a scheduling order, directing the parties to file briefs on a particular day or by a particular time. I'm very appreciative of that. And setting this hearing. The reason, obviously, is that it's necessary to have briefing. And I think in my 26 years, I've always done it. Is that while it's initially styled as an ex parte proceeding, meaning this is certainly not ex parte. Ex parte means the other side isn't here. Judge still talking. Certainly, there was sufficient cooperation between the parties, apprised of what's happening, and I want to make sure that I have before me a complete record to the extent it can be achieved in this period of time, and the party's position. Why is that important? It's important because, one, the issues are extremely significant. Two, the matter has urgency about it. And therefore, I have to act expeditiously, and I intend to do so. And I have to act in a way that takes into consideration the arguments of the parties. I think it's a fair way to do it. And I think that's the way I've tried to do it over the years. And I simply just want to acknowledge the fact that the parties have been extremely helpful in that regard. And I'm most appreciative. This was a very short timetable, but you certainly all have filed enough to get my attention and to address the issues. So with that, I'd like to proceed, and I do have some questions for the federal government. And I'm going to ask the parties where they do address the court to come to the podium, and you will note that there's two at the podium. This is being transmitted via Zoom. It's also part of a pilot project of cameras recording proceedings. And so Joe Neerman's screwing it up. Sorry, still judge. No camera on me. A blessing for everybody. Involved. There will be on you. And so it's important that you stand at the podium, that we record what you have to say. No one else can, just the court. So let's start with the federal government. And I'm the judge talking now. And let me highlight what it is that I want to address, because you've addressed a number of issues, and it's not going to be necessary to go issue by issue by issue. However, by reviewing the issues in my mind, it seems to me that it is necessary to understand whether or not the president complied with the statutes, which is 10 U.S.C. section 12406, which I have here. And it is a very short statute, but has a number of requirements. And so I need to know whether that statute was complied with. If it was, I think that obviously be meaningful. And if it wasn't, that'd also be meaningful. I've observed that when the president determined or acted upon his desire to federalize the California National Guard, he cited the statute. This was his authority that he relied on in naturalizing California National Guard. So this seems a proper place to start. When I'm the judge, I'm going to have this camera on. I'll take a different camera for the other sides. So I think that generally this will put this in context. If he didn't comply with the statute, simply didn't, then would you agree that there's no authority for the president under the present set of circumstances as he's defined them to federalize the National Guard? So this is Trump's guy now. That's a question. I didn't have a big question mark at the end, but what would be your answer to that? Our answer, first of all, this is Breck Shute on behalf of the defendants. I want to thank the court for giving us a chance to brief the case and appear before you today. Our bottom line is yes, the president complied with the statute for three simple reasons. That's not my question, so let's get it clear. My question is not that. My question is, if he didn't, I didn't say you did. You think he did, and we'll discuss that. But I'm looking at the reciprocal or the logical converse. If he did not comply with the statutes, then he didn't have the authority, did he, to federalize the California National Guard? I disagree with your answer, Your Honor. He would still have the authority, and it would not be something the court could enforce, nor would the plaintiffs be entitled to the type of relief that they're seeking in this case. Even assuming hypothetically that the president didn't comply with the statutes. So you're saying even if he didn't comply with the statute, he still has the authority to do what he did. If he didn't comply with the statutes, that is a procedural requirement. Even if that requirement were not complied with, the president still had the authority. Under what authority do you cite that the president, even if he didn't comply with the statutes, has the authority to nationalize the California Guard? The first sentence of the statute provides conditions and says the president may call into service members of the National Guard. So that is an express grant of authority to the president to take action to call to National Guard. That the plaintiffs ignored that language in the statute entirely and focused only on the second sentence of the statute about, I'm sorry, I don't think that is actually the first line of the statute, is it? Well, there's a precatory clause. Whenever the president, the conditions are satisfied, the president may call into federal service. Now let's assume he didn't satisfy those conditions. Is there authority if he didn't satisfy those conditions? Does the president have the authority, even if he didn't satisfy those conditions, to federalize the National Guard? The answer is yes or no, or I don't know. I think it's possible the president might have some other independent Article 2 authority, but he did not exercise that authority in this particular case. Do you want me to consider that possibility? We did not brief that issue in this case. The only thing the president invoked was this statute, and we believe he complied with the statute. But even if he didn't, our position is that it's not subject to judicial review. Okay, we'll get there. But we got to take it one step at a time. And I got to figure out what I'm chewing on. And is it non-judiciable? That's your principal argument. That's a major argument that you've advanced. And we'll have a discussion on that. But I need to know whether, if you can answer, what the parameters of my inquiry should be. That I simply look at with a statute and your arguments with respect to the statute to determine whether or not his conduct was lawful. I'm not looking at something as whereas Article 2, by the way, which, by the way, I've got it. So if you could point me to something, if you can point something in this book called The Constitution of the United States, I'll look at it. I'm not foreclosing you for making some argument. You want me to look at Article 2, which I did early this morning. And I did, and I was interested because it says in Article 2, it says the president shall be commander-in-chief of the Army and Navy of the United States, comma, and of the militia of the several states, comma, when called into the actual service of the United States. That's what it says. And Section 1246 actually talks about calling the National Guard into federal service. It says National Service : call. And as you correctly pointed out, it's got a big whenever, and it's got 3 conditions, and the president cited 2 of them, I believe. Not the first, but the second and the third. And we'll talk about that. That's analysis of the president made, and it's the analysis I'm going to make as well. don't know that I should make analysis of some possibility. I'm going to go ahead because I think I have your answer. And at any time, if you get inspiration from the Constitution and you want me to look at something, I'll look at it. Let's go to the statute. Essentially, is your argument that it's non-justiciable. I have a hard time pronouncing that. I think there is a sort of the argument about the non-justiciability is focused for the large part on the discretion that you find that the president has in making determinations under 1, 2, or 3. That is, it's absolute discretion whether or not 2 is met. That is to say, a rebellion or a danger rebellion. Or number 3, that the president is unable with the regular forces to execute the laws of the United States. You see, he found those were his findings in the order. We're talking about June 6th, June 7th, and June 9th or 10th. I'll get it right eventually. And he makes these findings, and it's your position. Look, these are his findings, and you, judge or courts, you can't review them because they're non-justiciable. And that the exercise of his discretion is complete in these areas. Have I got that right? Yes. Then let's get one little thing out of the way. And then we'll talk about that. Because the statute says that it is for these purposes, that is the federalization of the National Guard, shall be issued, shall, and you'll agree with me that shall means it's mandatory. It's sort of redundancy. Shall be issued through the governors of the states. Now, in this case, as I understand what happened, is that the president directed the Secretary of Defense to advise or to order the Adjutant General of the California National Guard to turn over command. I'm sure there's a better way of saying it, but to turn over command of the United States, because after all, the Constitution says that if the National Guard has been federalized, if it has been, then the president is the commander-in-chief. So as I understand it, what happened in this case is the president sent out the Secretary of Defense, and he sent, I don't know, letters, emails, orders, whatever they were, to the Adjutant General, and only ordered itself. In the order itself, it says, and I'll quote the order because you rely on it. He says, by the way, his tone is very normal. He's looking through papers now. This is when I'm here in this position, I'm speaking on behalf of the judge. If I go into the upper left corner, I'm speaking for Newsom's counsel. If I go into the upper right corner, I'm speaking for Trump's counsel. This way I could just keep talking and you'll hopefully be able to understand who's talking. So this way I can share the screen with you. It says, okay, he's back talking now. It says top of the order now, it says memorandum for the Adjutant General for the California National Guard through, the governor of California. And you say, you said through the governor, therefore it's through the governor. And I'm trying to figure out how something is through somebody if in fact he didn't give it to him. You actually send it to the Adjutant General. There's no argument here that you didn't send it to Governor Newsom, as I understand it. I mean, maybe I think he's probably got copies now, but I think the factual record is that it's saying sent to the adjutant general, and the adjutant general then provided the governor with a copy of the order. And it's your view, as I understand it. I mean, your view has several steps to it. But one argument is that means it went through it. And it would be the first time I've ever seen something go through somebody that it never went to them directly. They may have got a copy of it, but is that by through? That as long as he gets a copy of it, that it's going through? He's looking at these words here. Or is your argument then simply telling that writing on the order that it's going through the governor means it's through the governor? Because then anybody could write anybody in an order, anything on an order. And that's a classic case of ipsit ditsit. I don't know what that means. Of I said it, therefore it is. I don't think you're arguing that, are you? No, I think a key missing piece here is that under California law, the adjutant general issues orders in the name of the governor. So the governor's authority is in respect to the National Guard is delegated to the adjutant general, and he's in the chain of command, the Secretary of Defense, the DOD, and the order is properly issued to the adjutant general to issue those orders to the guardsmen. And they're called into federal service, and they're now part of the Federal National Guard. So you're saying that the adjutant general sits in the seat of the governor? The governor is in charge of the Constitution of the state of California. He's the commander-in-chief of the National Guard. So you're saying his adjutant general sits in the post of the governor. And therefore, if you give it to the adjutant general, you've effectively given it to the governor. And that's what's meant by through. Issued through the government through the governor to the adjutant governor general, because he's the person in the chain of command who effectuates the Secretary of Defense's order. There's something in the order that says you have to let the commanding general of the order of the army know something, and he sends it to his staff. And if he shows it to his governor, to the chief of staff operates as the implement of orders of the commanding officer. At least I think that's true of the military. That's good enough. That's your view. I think there's no doubt on this record that Governor Newsom was fully aware of this order. He objected to it publicly. We need to focus on the language of the statute that says the order shall be issued through the governors of the state. It doesn't say by the governors. It doesn't say with the governor, or that he's co-executive, or that he has a right to approve. It simply says pass through. It says the governor here is a conduit for those orders. He's not someone who gets to issue orders. He doesn't countermand orders. He's fully aware of the orders. So then why even bother putting in the governor? Why not just say to the commanding officer of the guard should be notified? Isn't there a contemplation, at least, that there may be a discussion between the commander-in-chief of the federal government of the force and the prospective commander-in-chief of the force as to the advisability of that force? And by the way, that person, unlike the adjutant general, as is the president of the United States, is the elected governor. The governor is also elected, and he's also the representative of the people, and serves a political role in that he or she, as the case may be, may have different views which that person may want to express to the president as to the advisability of it. And he has expressed his views publicly after it was nationalized. If the Congress wanted the president if Congress wanted the governor to have authority, they would have stated that. But here it says through the governors. There's no discretion with respect to the governor of California. Contrast the second sentence with the first sentence, which says the president may nationalize the state National Guard. The governor's orders shall be issued through the governors. There's no consultation requirement, pre-approval requirement. The governor is merely a conduit. He's not a roadblock. The president doesn't have to call the governor, invite them, Camp David, let's have a summit and negotiate for a week. Or what are the terms on which I'm going to call up the National Guard in your state? What are the terms of deployment? Whether there's one commander in chief of the government of the forces, the president makes a decision. The states are subservient to that decision. Wait. The president's not the commander in chief of the National Guard. He can become it, but he's not. He became the commander in chief. Either he did or he didn't. He did or he didn't if he complied with this section. Congress has said, this is the way you call the National Guard. This is the way the National Guard comes into federal service. That's what Congress said. Not the state. That's what Congress in the United States that passed this statute that said this is the way. If he did it that way, of course, he becomes the commander in chief. And matter of fact, that's what the Constitution says. So we have to take it one step at a time. And the question really is, did he comply with the statutes? That's the first question. And there's two steps in this process. The first step is the president issuing his order on June 7th. That's when he exercises authority on the first sentence of the statutes. That's when he became the commander-in-chief of the State National Guard. He called them into service. The second step is when the Secretary of Defense issued his memo to the Adjutant General. So let's take it one step at a time. The president issues his order. At that point, he's the commander-in-chief. So the issuance of an order, all the president has to do is issue an order rather than transmit it. And if he issues an order and then he becomes, at that moment, he becomes the commander-in-chief of the National Guard. Yes, and I think that the second sentence meant to recognize the fact that the state National Guards are a unique creature, both part of the state National Guard and part of the federal National Guard. And when the president decides to call them up, they're relieved of the responsibilities to the state governors, and they become part of the federal law enforcement and subject to the commander-in-chief's authority under the Constitution. And that's what happened when the president issued his memo. So the second step of the process is through the Secretary of Defense. Did he comply with the statute with respect to issuing those orders? And he did for three reasons. Number one, as we talked about, the order itself on its face complied with the statute by saying the orders are issued through the governor of California. It's the responsible official in the chain of command, which is the Adjutant General. That's the first step. Second step in the process is California law recognizes that the Adjutant General issues order in the name of the governor. And then the third reason why is that the Adjutant General acknowledges the order and immediately complied with the Secretary of Defense's order and mobilized his forces and put them in the chain of command subject to the President of the United States. There was recognition within the chain of command in California that this is a lawful order and it was complied with. Governor Newsom was aware of this order. He issued public statements. He spoke to the president on Friday night, even before this order had been issued. The president and Secretary of Defense complied with the statutes. The plaintiffs want to read this as, you say the two spoke. Do you have a record of what they said to each other in that conversation? I don't think we do. You can say, I don't know. You're not maintaining, he said, Governor, I'm going to nationalize the Guard. You'll get I'm going to do it through the Adjutant General, and you'll get the order tomorrow or in an hour or 3 hours or something like that. That's not in the record, and you're not urging that. No, but they certainly spoke about the situation in Los Angeles on Friday night. Yeah, but that happens when there's serious political unrest and concerns throughout the country repeatedly over a history hundreds of times. I mean, this is a country that champions the right to free speech and champions the right to redress grievances. That's also in the book. And so it's not unusual that, as a matter of fact, it's probably preferable from a policy point of view, but I'm not getting into that there be conversations between chief executives in order to see how to resolve any situation. But I don't have a record of that. That's not in there. And I don't know that I can sit around and speculate as to what they said or what they didn't say and so forth. I'd like to talk about your principal arguments about the justiciability of it because of its implications. Justiciability means that the court has no right to rule on this. That's what justiciability means. Going back to speaking as a judge. As I understand this, you're saying, you look at this statute, really look at this statute. The president, obviously, has enormous discretion to make particular findings. And, Judge, you ought to just not get into it because Congress has said that it is the president who exercises this discretion, not the courts. And we don't want a situation, or maybe for a variety of reasons, second guessing. The records are never as fresh as the event itself. And therefore, we don't want courts to come in a day, 2 days, 5 days later and start to second guess what was going on. It's the president who makes these decisions. So I looked in the statute because, as you correctly point out, the statute starts out with 3 micro requirements. Whenever means, to me, it means one of these things in this, it must be there. If it's not there, he hasn't followed the statute. Or the statute defeats the federalization of the Guard. Whenever the United States, or is invaded or in danger of invasion by a foreign nation, he didn't cite it, and it's not in front of me in any way, shape, or form. I would disagree with that because it is part of the statute. It is one of the conditions that Congress set, and our argument is that this statute gives deference to the president in judgments he can make. So just looking at the first prong, is there invasion? That is an inherently political question that the president gets to decide. It's not something for courts to decide. Well, I don't know. I mean, it just seems to me that we don't have to go there because the president of the United States didn't go there himself. Why am I looking at number 1 about an invasion when the president of the United States didn't rely on that? Because if prong 1 is non-justiciable, that's a strong indication that number 2 and 3 are not justiciable. Well, I don't know if it is or not. You have to read the logic behind that because the interesting thing about number 1 is it talks about a foreign nation. And peculiarly, in the operation of our government system, issues relating to foreign affairs sit differently than domestic affairs. And for good reason. Think about it. You can understand that those all sorts of things implicated by the foreign affairs power that aren't implicated in the domestic situation. So, we could spend a lot of time talking about that. And I'll take what you have said and I'll tell you what I think you said. I think you said, since it exists there in the first prong of the statute, it is indicative of the degree of discretion that the president has, to which I say, I think there are differences, between foreign affairs and domestic affairs. I think there are differences between the right to petition grievances. I think there's a right to free speech domestically. I don't know about foreign rights to free speech. What makes America great, different, is our Constitution and is our robust discussion of views of citizens with respect to that. So I invite perhaps a chat about that sometimes because it's interesting but that's not what I'm facing today. What I'm facing today is 2 and 3. And what I'm asking you as to 2 is, you have said that as to 2, there's a rebellion or a danger. Now, the president has found that there is a rebellion against the authority of the government of the United States. That's what he says in his order. He doesn't talk about a danger of a rebellion, I don't think. Am I correct? He doesn't say there's a danger. To the extent that there, I think he's invoking both. Okay, you think he's invoking both. Be that as it may. We're talking about his discretion. And if he has 100% discretion, complete discretion in that area, then that supports your argument that there's nothing for me to do. He exercised it. It's not like he didn't pay attention. I mean, I don't know what he paid attention. I know anybody ever pays attention to. My point is, he did cite it. He cited it. And you're saying he cited it when he talks about a rebellion. He also talks inferentially about a danger rebellion in the language he cited. And I haven't gone through it yet. Or the president is unable with regular forces to execute the laws of the United States. So what I understand that to mean, I'm not sure what regular forces. Who are the regular forces? For example, LA Police Department. Are they police department? Are they sheriff's deputies? Are they, quote, part of regular forces? Or are regular forces only the troops, the Marines, or the National Guard? What is meant by regular forces? In the context of this statute, I think regular forces means everything other than the state National Guard. It could be local police. It could be federal marshals. It could be the Marines. So therein lies the joining of the issue, because the president has said these things existed. These conditions, one of the 3 of them has to exist, and the court's view. These conditions existed, therefore, the rest flows. Now, the question is, does the court have any role in looking to determine whether or not these conditions existed? And it's the federal government's argument, no, you don't. Since he has complete discretion, then the issue becomes non-justiciable. So therefore, my question to you is, what authority do you have for that proposition? It's the take care clause of the Constitution, which says that the president take care that the laws are faithfully executed. That's a delegation of authority in the Constitution solely to the president of the United States. And his prong 3 talks about the president is unable with regular forces to execute the laws of the United States. So if the president determines that with regular forces, he's unable to carry out his constitutional responsibility to take care the laws are faithfully executed, then he may properly invoke prong 3 of the statute. And I think that's what he did. And the evidence in the record that we submitted, the Santa Cruz Declaration, explains in detail, it's in ECF 22-1, all the inability of ICE in Los Angeles to enforce the federal immigration laws. I won't go into detail, but paragraph 7, 8, 9 through 17 talk about specific immigration enforcement actions that could not take place in Los Angeles because of violent mobs and rioting and pinning down federal officers in the federal building in Los Angeles. In light of that evidence, which happened on June 6th and June 7th, that evidence was available to the president. He talked to Governor Newsom the night before, and he concluded federal law is not being enforced in Los Angeles. So you're saying there's evidence behind these findings, right? He would have had advisors who consulted him. This is a declaration that was put together after the fact. But you're telling me the president acted on evidence. Of course. Okay, then fine. Did he have to? Oh, sorry. Did he have to? He didn't have to at all. He could have just decided that he thought that there's a rebellion or there's a danger of rebellion under 2A, or 3, that he couldn't execute the laws even though he saw no evidence of that. It would be a non-justiciable for the court, regardless of whether there's evidence or not. So I don't have to look at your evidence for this argument. Got it? Because if he simply says it, it's so. And your authority for that is that under the Constitution, he's taken the obligation to take care and to execute the laws. That's the authority. And therefore, as I understand your argument, he can do it any way he wants to. I mean, he can make any finding he wants to, with or without evidence, if in fact he has discretion in this area. I don't want to overlook the Supreme Court precedent like Dolman v. Specter, Baker v. Carr. That statutes exude deference to the executive, where there's a textual commitment to this question to one branch. There's not standards for courts to review. That's committed to the president's discretion to decide. And therefore, the courts simply have to accept the fact that you have a statute that says one of 3 things have to exist. And the courts have to then say, if the president finds it, that's the end of the matter. That's the way the statute works. There's no judicial review. Even if there were some limited judicial review, but what's that? I think the question would be, can I examine the record and determine whether the president made the necessary findings, right? So if the president had not made any findings, that might be a harder case for us. But here you have findings by the president, but I can't look at the basis of those findings. Well, even if you want to, we have a declaration of the record. You're telling me I can't. You cannot. All right, then I'll take it at that. You say I can't. I've tried on your good nature for 45 minutes. Now let me get to them. Thank you very much. Now, when I'm talking on behalf of the Gavin Newsom, I'm going to be up here like that. So this is when I'm Gavin Newsom's lawyer. I'm going to be here. When I'm the judge, I'm going to be here. So why don't you identify yourself for all the fans out there who want to know you are. I'm glad you think they're my fans, Your Honor. This is Nicholas Green from the Office of the Attorney General on behalf of the Governor of Newsom in the state of California. Okay, so I'd like you to address the points that have been raised by your colleague in response to questions that I had, because these are the questions that are turning in my mind, and I need some clarity. Go ahead. Thank you, Your Honor, and I appreciate the court's time, guidance, with respect to the issues on your mind. I want to start by answering the 2 questions you posed to my colleague at the start. Was statute complied with? And if it wasn't complied with, is there any other basis for the federalization or the guard? The answer as to both of those questions is no. So let me start with whether the statute was in fact complied with. As the court has correctly identified, there are 2 questions to ask there. First, were any of the factual predicates in 12406 1 through 3 present and satisfied? And that is a reviewable question. And second, even if they were present, which of course we dispute, was the order issued through the governor of California? The answer to both of those questions is no. And that's as far as the court needs to go when it comes to the guard. I want to put a pin in the Marine Corps because that's a different inquiry. We'll talk about the Marines at the end. But as to the guard, our position is they were not lawfully federalized, and the court can review those 3 factual predicates. And I think what the court was getting at in the colloquy with my colleague is exactly right. In the first portion of the statutes, what the statute is setting forward is 3 sets of factual conditions. And then it requires the court to look at the facts on the ground and apply them to the laws written. Courts do that all the time. And there's nothing special or unique about this statute that takes it outside the realm of judicial review. And I actually think that it's interesting that my colleague refers to Baker versus Carr, because, of course, in that case, the court concluded that the statute was reviewable. And the standard is whether there is no judicially manageable way of making a decision. That is not what is present in these three factual predicates. The other thing I note, Your Honor, is that it's important to look at the two different parts of the statute. Yeah, the first three prongs, those are factual predicates. Whether they exist or not is something the court can determine. The second half of the statute talks about the president's ability to then, if those predicates are satisfied, call forth the guard. And it says the president may call into federal service members of the National Guard of any state in such numbers as he considers necessary to repel the invasion or suppress the rebellion or execute those laws. That is a very clear congressional delegation of discretion to the president. That language is not present in the first three factual predicates. And that's a pretty good indication, Your Honor, that Congress knows how to make a distinction between things that are committed to the president's discretion and things that are not. Well, this is what I wonder, the whenever. And then it says 1, 2, 3. If the president had complete discretion, why wouldn't it say whenever the president finds, or whenever the president concludes, or in the sole discretion of the president, he finds 1, 2, or 3? They don't say any of that. They don't even mention the president in the first three. Oh, they do. It says but my point is, if it were read the way the government has urged me read it, it would have been worded entirely differently. You would have put the discretion in the beginning, not at the end. But if you put it at the end, then I said you could have said everything is discretionary or in the mind of the president, but it doesn't say that. We deal with the statute as written, and it's written this particular way. Why don't you address the question I find interesting is the justiciability of the question. In particular, you say, look, courts have to stay out of this. And that the president is duties to faithfully execute his duties with care. Of course, we're talking about the president exercising his authority. And the president is, of course, limited to his authority. That's the difference between a constitutional government and King George. It's not that a leader can simply say something and then it becomes it. It's a question of a leader, a president or a governor, following the law as set forth in both the Constitution and statutes. That's what a president, a governor, or any leader must act under. Otherwise, they become something other than a constitutional officer. So that's the argument. And I'm interested in your response when it's urged upon me that, look, these issues are not subject to review. He's got a complete discretion in this area. So I think 3 points in response to what you just said, Your Honor. Aside from the fact that I agree with pretty much everything you just said, the first response is that I read the Constitution a little differently than my colleagues do. While it's true that Article 2 requires the president to take care that the laws are faithfully executed, Article 1, which comes before Article 2, provides the Congress with the authority to call forth the militia. And that's what this statute's about, the authority to call forth the militia. It's true, by statute, Congress has delegated that authority to the president, but it's not a core Article 2 power, whether to call forth the militia. Whereas the provision you read, Your Honor, says when the Guard has been federalized, then the president is the commander-in-chief. But decision about whether to call forth the Guard, that belongs to Congress. So it's not a core unreviewable Article 2 issue. That's the first point. The second point is, I think, more important perhaps, and speaks perhaps to the point that you were making, Your Honor, that the version of executive power to police civilian communities that the government is advancing is breathtaking in scope. And they suggest that there are no guardrails, that is unreviewable by the courts, and I'm sure we'll get to this later, that the Posse Comitatus Act doesn't even apply. They're saying, Your Honor, that the president by fiat can federalize the National Guard and deploy it in the streets of a civilian city whenever he perceives that there is a disobedience to an order. That is an expansive, dangerous conception of federal executive power. And that's, I think, sort of a second point as the reviewability question. The third point, Your Honor, is just looking at the statute. And that's the point I was making just a minute ago. The statute provides, as you say, whenever these conditions exist. It's actually a factual question. And this Congress saying the president has to make a determination as to whether these facts exist. But that's something a court can do. A court can look independently at the record and decide whether those facts exist. And I think it's striking, Your Honor, that the government just stood here and told you that the president could make no findings as to the third paragraph, and that would still be a lawful exercise of presidential power. I mean, I wonder, even in the context of the power of appointment the president has. I mean, if the statute says whenever a vacancy exists, the president can appoint to fill vacancy, and so he declares a vacancy, even there is no vacancy. There's no vacancy there. He says there's a vacancy, so I'm appointing so and so to this position, and you say, wait a minute, that's not justiciable. If the president finds a vacancy, there is a vacancy. That's it. If the president finds there's a rebellion, there is a rebellion. If the president finds this or that or so forth, and I try to distinguish in my mind, how is that any different from what a monarch is the status? He says certain things, he finds certain things, and he does certain things. But that's not where we live. I live in response. We live in response to monarchy. This country was founded in response to a monarchy. The Constitution is a document of limitations. This is going terribly, by the way. And enunciations of rights. This is going really badly. Gavin's going to win here. Line drawing is important. It is important because it established a system, a process, a system of regularity, a system of norms, and a system how you go forward and how you govern yourselves and how you implement the basic dictates of the Constitution and of the Declaration of Independence. That's what the system is. So I try to think about that. As a former and a hometown resident of Boston, I think I would also say to Your Honor that it's, that the provisions of the Constitution related to the militia and the domestic use of law enforcement flow from the initial concerns of the deployment of military forces to police the civilian population that animated the founders. So I think that this tradition of civilian law enforcement and the non-use of executive military power to police civilians flows from that very beginning, that foundational moment of the Boston Massacre. And it flows all the way to today. And I think Your Honor is right to be concerned about sort of the broader constitutional implications. So I want to ask you a question about the Posse Comitatus and discuss the Marines. Because I think we're not talking about federalizing the Marines. The Marines are federalized. And when I read through your briefs about, well, first of all, we all know the Posse Comitatus Act prohibits, it's a prohibition. It says you can't do this. You can't substitute yourself in for law enforcement in that area, making arrests and so forth. And I think what you have said and I'm going to ask the government the same thing, You said the Marines might do this. They might do this, but they haven't. There's no evidence before me that the Marines have actually done these things that are prohibited by the Posse Comitatus Act. And I'll also say that the president, when he invoked his authority, I don't know whether he specifically said or it's an inference that he's not invoking what I call the exception to the Posse Comitatus Act. That is, there is a provision. I don't know what's it called? The Insurrection Act? That's right, Your Honor. There is an exception to the Posse Comitatus Act, and that's the Insurrection Act. But the president said, I'm not relying on that. So I don't understand how I'm supposed to do anything with the Marines, to tell you the truth. What's your argument that I should do something with the Marines? So, yeah, let me try to adjust that for Your Honor. The first thing I like to say, just as a factual matter, is that I have been told by my client, the officer of the governor, that within the next 24 hours, we understand that 140 Marines will replace and relieve National Guard members in the city of Los Angeles. And if you'd like us to submit a supplemental declaration, I'm told we're able to do so. Even if that were not the case, Your Honor, the fact that 700 Marines have been mobilized from 29 Palms, moved to Cecile Beach, and made ready to deploy on the streets is evidence enough that the injury is certainly impending, and the violation of the Posse Comitatus Act is certainly impending. I'd also point the court to the public statements of our party opponents, who've been very clear about what the real the role of the Marines is going to be. They haven't tried to hide that ball. In fact, they said the rules of engagement may allow them to briefly detain civilians. I get a little nervous doing declaratory relief actions, saying, well, if they do this and you do that. It seems to me that we are in a situation in which circumstances and perhaps court orders will dictate how people behave. I mean, that's actually the idea of a court order, isn't it? It comes to some conclusion that the party follows court orders. That's right, isn't it? The federal government's agreement with me on that issue. Okay, whatever order I issue, if I do issue an order and I'll issue a decision, I assume it'll be followed. And that may very well impact decisions as to what the conduct will be in the future. I just have a hard time starting to reach out and saying, we have the Posse Comitatus Act, that's right. And by the way, you can't do this, you can't do that, that's right. So I'm going to order them not to do that because that's in the Posse Comitatus Act, and I'm afraid they might do it. I sort of don't think that's my business. I think I don't get into that type of analysis unless it becomes real. If it becomes real, obviously, it's the court's obligation to address it. But it seems somewhat speculative, and it seems simply a view of the future as distinct from what is presently being done today on this record. Your Honor, I appreciate the court's concern, and I want to make 2 points of response. The first is that there's a PCA violation, and I hope the court will indulge me with that PCA is Posse Comitatus Act. There's a PCA violation right now. It's not disputed the Guard is out there right now enforcing law, and they're federalized. In fact, they're no different than the 101st Airborne right now, because they're under the command, purportedly, we argue it's unlawful, but purportedly under the command of the federal authorities. If it turns out that the order federalizing them was improper, and their conduct then, their controls returned to the governor of the state of California, doesn't that moot it? There are 2 ways to think about it, Your Honor. I think purposes of this hearing, you could conclude that it's substantially likely that the order was unlawful, or you conclude that regardless of whether the order was lawful or not, what's happening with the troops right now violates the PCA. In either case, what we're asking for on this record in this circumstances is the narrow relief that we specified in our proposed order. And that is really to prevent the immediate irreparable harm that is happening right now and will continue to happen. Well, that's an issue I have to face squarely, whether the guard was properly nationalized. I think that's the issue in front of me in the first instance, and I'm prepared to address that. Let me hear from the government. He's going to rule against Trump here. Your Honor, a couple responses. We talked about the relief that they're seeking. It's not narrow, it's extraordinary, and it all hinges on supposed violations of the Pars Comitatus Act. The proposed order accepts the order. The provisions they're seeking today, they're fine with calling up the National Guard. They're only asking you to enjoin that force from staying within federal property. What they don't want is the Guard to go outside of federal buildings to participate in immigration raids. The relief they're seeking has nothing to do with the supposed violation of the statute. As we explained in our brief, and as I think as you recognized, it's entirely speculative whether there will be violations of the PCA. And one piece of evidence that I think is critical is the nail declaration that we attached to our submission, ACF 22-4, which paragraph 7 and 8 explain that the Guard is under order strictly to protect federal property and personnel and not to engage in domestic law enforcement. And let me quote paragraph 7, which I think is the whole ball game with respect to the relief that they're requesting today. It says, this is from the commanding general at North Cal. The guardsmen of LA are, quote, protecting federal personnel of engaging in official. It's too fast. He's reading from the order. Federalized California National Guards are limited to those protective operations, not that they are not performing law enforcement or any other functions. Paragraph 8 goes on to specific functions that the Guard is performing to protect ICE, law enforcement personnel, and federal buildings. What they're seeking to enjoin is the guardsmen leaving the federal buildings and participating in ICE operations in violations of the PCA. My sense of it is that we have an always changing set of circumstances on the ground, and different things happen at different times. And people react to it differently. It still strikes me that as a court facing the issues that have been fully briefed and argued, I have to make a determination as to whether or not the Guard was properly federalized. And that's what I'm addressing here. Unless the Attorney General says don't bother with that. But they're not saying that, right? We're not, Your Honor. Yeah, I didn't think so. You're assuming that even if you're assuming you find a violation of the statute, that the Guard was not properly called up, you could not possibly award the relief that they're seeking, because the relief that they're seeking accepts the Guard being properly called up. They just want to enjoy potential violations of the PCA, which the guardsmen are under orders not to do already. So if you find a violation, well, how do you respond to that? You can't see them, but they disagree with you. If there's a procedural violation of Title 10, that's a foot fault. Then give us the opportunity to cure. However you read the statute, give us an opportunity to issue and correct the papers, white out the orders, and we'll send them in the proper way. But don't issue any type of injunction that would countermand the president's military judgments and orders on the ground if you find a foot fault. Well, if they're unauthorized, it's not something you overlook. Your argument is that they are all authorized, and it was correct. Well, if it's correct, it was correct. And there we are. Now, I know you're arguing, as a good advocate would. Look, even if you disagree with me, because sometimes courts disagree with one side or the other, give us another opportunity to do it right. do it consistent with whatever way you think is right. And to that I say, you sort of take this one step at a time. Because when you start getting into where do we go from here, you start sort of an interesting negotiation session in which the court becomes almost a party to it. Is this good enough? Is that good enough? Is this good enough? And I think I have to intellectually and under my duty see that the laws are faithfully executed and make a first determination. And you're saying to me, and I'm not ignoring this, if you do make that determination and it's adverse to the federal government, give us an opportunity of going back. And I say to you, I haven't thought this through, but I think if I do find that, or I don't know, I'm going to consider your arguments today. But if I do find it, whatever your actions are, you still have, I'm not saying don't do, I may say something if I do about what you've done, but what you're going to do, I don't know. I don't know what you're going to do. Because I think it depends in part on what is the situation on the ground. In part on what is the situation throughout the United States, or what is the president trying to accomplish here, or what does the president perceive the problems to be? All of those are outside my realm. I didn't get that job. He's got that job. But you want to second guess him on that job, Judge. And I don't know what he'll do. I don't know what the Secretary of Defense will do. But I know what I have to do. I have to look at what the record is and make a determination based upon the record before me, not the prospective record. And that's why I'm concerned about starting to talk about the Marines. That's exactly why. That's exactly. I mean, you've hit it on the nail. That's correct. I don't want to talk about the Marines because I'm not quite sure what they'll do. I think what they'll do is follow the law. That's what I think. You should also assume that the Title 10 force will follow the law. And again, you're not just being asked to decide the merits. You're being asked to award an extraordinary injunction, an injunction that would countermand the president's military orders that would threaten federal personnel and property in Los Angeles with potential violence and destruction. And the injunction they're seeking is a mismatch for, well, the issue is then that their position, they're not advocating violence. They're not advocating that some federal officer be hurt or put in harm's way. What they're telling me is that the National Guard, under the direction of the governor of the state of California, as is constituted in the state constitution, will protect these individuals when they're in California. No, they won't. When they're executing their job, doing their responsibilities, they will do it. Then why did he call them up then? Why didn't he activate them then? They're saying the command of the National Guard should be the governor, because that's the way the institution is set up. And 12406 has not been met. But I appreciate what you're saying. I'm not suggesting that this is a run-of-the-mill case. I know that. What I'm urging is that the court has to balance the equities. And I will, absolutely. I think I have to balance the equities. And may I make two final points? Of course, go right ahead. The first point is, if the court is inclined to issue any type of TRO injunctive relief, label it a preliminary injunction. We've had full briefing. We've had an adversarial hearing. If you're going to issue a TRA, call it a preliminary injunction so it's very clear what the appellate rights of the parties are. Second, I'll explain that later. Second, if you're inclined to injunctive relief, we'd ask for a stay to appeal for 48 hours. I'd like you to address the final points of the government as to what the issue is made of converting it to a preliminary injunction. The defense are satisfied that it can be converted to a preliminary injunction if I issue one. Well, I think if you issue a TRO, it would essentially be a preliminary injunction. Your Honor, we don't have a particular position on whether the court should issue a TRO or a preliminary injunction. If the court feels that preliminary injunction is appropriate, we don't object to that. As to the stay pending appeal, we would vigorously oppose that for reasons I think are self-evident in our briefing. Clearly, there's an ongoing urgent situation in Los Angeles that needs immediate resolution. That's why I moved ex parte. That's why we asked for accelerated schedule. We would strongly oppose a stay pending appeal of the preliminary injunction. I did want to address just a couple of points that my colleague raised, if I may, Your Honor. First, I do not read our proposed order in the same way that my colleague reads it. There is no concession as to the merits of our 12406 claim, and I would just direct the court to paragraph 9 of the proposed order, which says plaintiffs are likely to prevail on their claims that defense actions are ultra vires, including because they violate 10-12-406. Well, that answers this question. And if I may, Your Honor, I understand we've been going a while. If I can make one final point for the PSA, a picture speaks 1,000 words. And I would, well, it used to. Now the problem is that it speaks 10,000 words. Well, fair enough, but this is ICE's own photograph. And it's a docket 39-1. And if this is not domestic law enforcement by the military, it's unclear to me what would be. And he's waving a picture there. Thank you. We're in recess. I want to advise the parties. I will have an order out. Very soon. Very soon. And I'm hopeful that I can get out today. Thank you very much. And we're in recess. And they're all clearing out now. And now the session ended. Okay. So what do we got? What do we got? I'll tell you right now. He's ruling in favor of Newsom. That's what's happening here. That's a situation where what we saw is a judge who is ruling in favor of Gavin Newsom, not to the surprise of very many people. What the reason that Trump's counsel was asking for it to be a preliminary injunction instead of a TRO is because a preliminary injunction is appealable. Temporary restraining order is not considered a final order. You can only request an appeal on an order that is final. Now, this hearing was to determine the outcome of a TRO. So what's the difference here? They're both forms of injunctive relief. What is injunctive relief? Injunctive relief means I'm coming to the court, asking the court to issue an order to make something happen, to stop something from happening, or to make someone do something. That's what injunctive relief is. Issue an order that's going to alleviate some tense situation. You have to establish there's irreparable harm. You have to establish balancing of equities and a likelihood of success on the merits. So that's how you get injunctive relief. Injunctive relief normally starts with a TRO, which is an abbreviation for temporary restraining order. That usually lasts for a very short time. Then after a TRO, that's usually ex parte, which means, so the way it operates is one party goes running into court, says, oh my God, there's a crazy calamity. I need you to sign an order right now. Let's talk about your garden variety situation, okay? I come home and I see there's a bulldozer outside my house, and this guy is planning on bulldozing my home in the next 6 hours. And I'm like, what the hell are you doing? He's like, well, I bought this house. No, you didn't. It's my house. I go running to court and I say, hey, court, I need an order from you directing that they are prohibited from bulldozing that house. If you don't issue this order, my house is going to be destroyed and it's irreparable. I can't put that back to make it look the way it was. So the court, so now I would go in, the other side, the defendant is not there. So I would be running in there ex parte, meaning that the court doesn't have the benefit of hearing the other side of the story, they're only hearing from the moving party. So that's when you would sign a temporary restraining order. Because it's ex parte, because there's only one side there, the plaintiff is there, the defendant is not there, and they'll try sometimes to call the defendant on the phone, but it's still considered ex parte, it's still considered a TRO. The relief, it'll be like, okay, no one can do anything. We'll keep the status quo here. No one can do anything with bulldozing the house until the parties come back in here for a hearing, and I want you to serve your papers, Plaintiff, serve your papers on the defendant within the next 36, 48 hours. This is how you serve your papers. Serve it by mail, serve it by email, serve it in hand, whatever it is, direct how it's supposed to be served. And the other side, defendants, have a chance to put in their opposition. Sometimes they'll give an opportunity for the plaintiff to put a reply. Sometimes they won't. And we'll all come back in here in 10 days. And the TRO is in effect for a very short, it's got the shelf life of its CT fly. It's supposed to be dead within 2 weeks because you're supposed to get back into court after both sides have had an opportunity to put their side in writing. Now, assuming that we come back in 2 weeks, during that period of time, it's a TRO or temporary restraining order. So now when you come back to court, and the other side, now the defendant had a chance, they are going to be notified. If the plaintiff does not notify them properly, the TRO automatically dies. It has no validity. So they're going to notify. They're usually going to go running back to the house, say, here's the TRO. Here you go. You can't bulldoze the house. So they're waving their face. And if they're ignoring them, they'll show it to a cop and have police come down there and say, you can't bulldoze the house. Here's the court order. They'll look at the court order and they'll say, okay, you can't bulldoze the house. So now now they got a full set of the copy of the papers that the plaintiff brought, what the cause of action is, what facts they claim. Now the defense can come in and say what their side of the story is, and they put in their affidavits as what the facts are, and they'll put in their arguments as to and memos of law if they want, or whatever it is, legal arguments that they have that they're standing in the right. So they'll put forward their facts and their evidence and their legal arguments, and they submit that to the court. And they have to get that in by a certain deadline. And then within a day of that, if not that day, all the parties come back before the judge. Now the judge decides, okay, you guys have a lawsuit with each other. Who owns this house? Who has rights to this house? That could take years to settle. Should I issue a preliminary injunction? Preliminary injunction is an order that would last for the duration of the case. So, and that will last until there's a final determination. Whose house is this? Is there a right to bulldoze this or not? Often a TRO that's signed off on will be converted into a preliminary injunction. It's just it'll be a lengthier period of time. Why is it that that's a lengthier period of time? Because now the court has had an opportunity to hear from both sides. Hear the facts on both sides, get briefing from both sides about the legal arguments. So that's why that is going to be the ground rules that both sides are supposed to be working under for the balance of the case, until there's a final adjudication by the court on the underlying merits. So that's a preliminary injunction. Well, let's say this plaintiff goes to court and gets a TRO. And I want to now say, wait, I need to bulldoze this house. I need to get moving on. I'm the defendant trying to bulldoze the house, or you're the defendant trying to bulldoze the house, and you're like, we need to get moving on this. I'm supposed to have a new house built up here within the next 3 weeks. I need to have this thing bulldozed today. I can't sit around. So I want to appeal this order. You cannot appeal a TRO. You can only appeal a preliminary injunction. You can only appeal it once it gets converted into a preliminary injunction. And sometimes the terms of preliminary injunction may be slightly different, modified based on what the court finds after it goes through both sides, both arguments. But that's the only thing that's appealable. A TRO is not appealable. Why is it not appealable? Because appeals are reserved for a final determination. And when you're seeking injunctive relief, the preliminary injunction is the final determination. A TRO is considered not a final determination. So what the Trump lawyers were saying is, I know we're here on a hearing for a TRO, but this is a weird situation where both sides have briefed it. Let's treat, if you're going to grant their order, give them injunctive relief, please make sure that you call it a preliminary injunction, not a TRO. Because if you call this a TRO and tell us we have to come back in 3 weeks, well, in that case, we can't appeal it until it turns into preliminary injunction. So if you're going to give the injunction, if you're going to say that they won, then please make sure you call it preliminary injunction. That way we can go straight to the appellate court and have you overturn, have them overturn it. And please stay your order. Don't just say they have to get removed today. Give us 24, 48 hours to file an appeal, that if we file an appeal, your injunction, which would be saying basically, hey, National Guard, you're no longer under Trump's control, that would be stayed, and they would stay in their control as long as we file an appeal within the next 24, 48 hours. So please make sure it's a preliminary injunction, and please stay your order. And then this way, in other words, recognize you're just a district court judge and that this is a little bit an unusual circumstance. And for you to be making a determination here is you're probably kind of guessing a little bit, and it's probably better decided by appellate court. And frequently, especially an issue like this, where the district court basically seems to not be sure. He's like, I don't know. Is this something I'm allowed to weigh in? Is something I'm not allowed to weigh in? That's the type of scenario where a district court judge will often say, I'm going to stay it pending the federal government actually bringing an appeal. And if you bring that appeal in the next 48 hours and they decide to grant the stay until they get to hear it, in that case, my order of the injunction in favor of Newsom will be held in abeyance. It won't go into effect. So that's what he was saying there at the end. But so now you might be asking yourself, what is the logic that's being applied here? What is the basis for them to be saying this statute seems like it's right in the sweet spot of what Trump's allowed to do? Why is it that what the hell are we even talking about here? How can anyone reasonably come to a conclusion that Trump is that Trump can lose here? I mean, if you look at this, it looks very much. By the way, if you could please hit like and subscribe, I would really appreciate it. I should take this down, though, banners, because I think that was an effective way of me doing this, by the way. I really liked the way it came out in the end. I'm sorry I couldn't pull up comments from Allegan News when in the middle, but I wanted to jump in. I wanted to try and keep it clear, and I thought if I pull up comments, it's going to just blow it out of the water. So what is the logic in the argument that the judge is looking to use to try and knock this out? And I will tell you, he looked like he sounded like he came in from a Gavin Newsom perspective. So his argument is that his question is really, what role does he have here? Is he allowed to review the decision making? What decisions of the president is he allowed? Would Trump agree he's allowed? The court is ever allowed to review? Are you saying it's just that he can never review anything here? And that's pretty much what Trump's lawyers said. So he went on this whole exposition about how, well, this is not a monarchy. In that case, you can just say something is so and then make it so, and even if there's no findings or anything like that, that doesn't seem to make sense to me. And he also looked to the language of the statute. And the language of the statute says whenever we have one of these scenarios, there's a rebellion, we have the president's unable with the regular forces to execute the laws, the United States or any Commonwealth possessions invaded or in danger. Whenever one of these scenarios is here, then these are the things that happen for the president. The president may then call in federal service. But how do we know whether or not this whenever scenario, this condition precedent, you have to have some set of facts that are in play in order for the president may call into federal service members and units of the National Guard. Well, who makes that determination? So Trump's lawyers were saying, we get to make that determination. He's the president. He has to decide that. The Breyer seems to be reading this as saying, no, I can decide whether or not the president was able to. That's a fact question which the court can decide. And if we decide that, in fact, it's true, then the president may call into federal service members of the units of the National Guard. If we decide that there is a rebellion, then the president may call it in. But not that he, by fiat, without even looking at any findings. And at the very least, he has to go through finding. He has to come to that determination somehow. And if he has to go through that determination somehow, at least maybe the court should decide whether his review and coming to that conclusion was reasonable, and there should be deference given to him. And I don't think there's any. I don't know what statutes there are which would say who's supposed to make the determination whether we have a situation number one or a situation number two or a situation number three. Because I do think it's a fair way to, when you're trying to interpret how a statute is meant to be read, I do think that it's a reasonable question to say who makes this call. And to just assume that the president makes this call, you have to pretend that Biden is president. And he says, I claim that I'm unable to do my regular forces, so now I'm going to send people into Oklahoma, and I'm going to take over the Oklahoma National Guard and take over the Cornhusker game. Whatever the hell, that would be Nebraska. I'm going to take over the Sooners. You know, you'd be like, what the hell's going on here? That sounds kind of like what a monarchy would be. So that's why they're saying when it comes to determining these factors, it kind of makes sense to say the court can review it. But even if the court can review it, one thing that didn't come up at all is what yardstick would they use? They're reviewing it afresh. That doesn't seem to make sense. You would think you should at least give a lot of deference to the president. But how do you read that in here? So that's really what the primary focus he had was that he was dealing with. If you have questions, by the way, about other parts that came up during the course of the argument here, because when I'm talking and just sort of repeating words from both sides, it's very challenging for me to be processing the strength or weakness of different arguments. But I do think that that's a reasonable question to ask. I hate the fact that I do think that that's I hate the reality of it, but I think it's a reasonable question to ask. But then I have to ask myself a different question, which is, so if there's an emergency situation, so what's he supposed to do? Go to the judge and say, hey, can you declare it that there's a rebellion here? That doesn't seem to make any sense. Can you declare that I'm unable to execute my hey, Daddy, I can't execute. Can you please agree that I can't execute? That doesn't make any sense. That makes no sense at all. That makes no sense at all. So the process that the court is envisioning here seems to make no sense. So the problem here is that the statute is not sufficiently articulate as to how his termination is made. Trump's team obviously wants to say president's call as to whether or not these three conditions exist. And the other issue that he talked about, that he was talking about in the very beginning, was what does it mean when it says shall be issued through the governors of the states? So Trump's counsel was saying that doesn't mean the governor himself. You have to walk up to him and hand him papers. Not that he wasn't aware of them. He was aware of them. You give it to the person's chain of command who's overseeing the guards. And that would be the adjutant general. That's who we issued our orders through. So when it says it's not issued to the governors, it's through the governors of the states. Through them, meaning through the powers that they have, go to their chain of command, the person who deals directly with the National Guard, which is the adjutant general, and give it to them. And you're acting through the governor. Because essentially what's happening here is that he's taking over these forces that are considered Gavin Newsom, the commander-in-chief of the California National Guard, and they're now being basically conscripted away from Gavin Newsom's army into the federal army. So, and that this statute is what gives license for the president to conscript them and take them away from Governor Newsom. So now the question is, what steps need to be done, if any, and what's considered, what does this even mean when it says shall be issued through the governors? And does he need to have his consent or not? And obviously Trump's attorneys were like, that doesn't make any sense to say that he has to get the consent and he has to invite them to tea and say, please let me have them. Then you don't need a statute. No, this doesn't make any sense. Which I agree with Trump's counsel on that. But he's concerned that his primary concern seems to be about whether or not he can make a determination and say, okay, the court needs to reach conclusions as to whether or not the president was able to establish with regular forces. That was another thing he was talking about. Is like, what does regular forces mean? Does that mean the military? Or does it mean ICE? When we're talking about executing laws of the United States, that doesn't mean the Army and the Navy. Because the Army and Navy are not ever effectuating laws of the United States. Laws of the United States are being done by ICE, the IRS, the FDA, the EPA, the SEC. They're the ones who are executing the laws of the United States. The DOJ. They're executing the laws of the United States. So I thought that was ridiculous. And they were considered generically forces. To try and read this as being military or Navy, and that's the only, he's only able to do it. So it's like if we're at war somewhere, in that case, and our Navy's not enough, in that case, you can call on the California National Guard. If we go to law with Mexico and then it's not enough, we can call on the California National Guard. It wouldn't say to execute the laws of the United States. It wouldn't say that. So I thought I felt like that was a bad faith reading, which was indicative of a direction that Breyer wanted to go from the outset. When he starts talking about what regular forces means here, to try and say that maybe we haven't reached, number 3, that sounded to me like a bizarre read that's tilted against Trump. Because when you say regular forces to execute the laws of the United States, that's not, you want to try and read that as talking about as the Navy and Marines and their inability to get something done. That makes no sense. It has to be talking about the DOJ, the ICE agents, or IRS, or the SEC, or the FBI. It has to be talking about that. Because they're the ones executing laws in the United States. So, but there's one more point I want to make to you, which is the Lululand that Judge Breyer is living in. The crazy, insane la-la land. Like which shows that he's so out of touch with what reality is in this scenario that it's almost dangerous to have him decide in this case. It's not just that he's left-leaning. And I don't know that he's left-leaning or he's like, so liberal-minded. He's so open-minded that his brains have fallen out. But I'm going to credit my mother for teaching me that phrase. He thinks, he's like, this is all a question as to who's going to run the National Guard, the California National Guard. It's either going to be Gavin Newsom running the California National Guard or it's going to be Trump. But in either scenario, the California National Guard obviously is going to be helping ICE protect ICE. They don't want to see something bad happen to ICE. Obviously, that's what's going to happen. The only question is under whose control are they? Are they under President Trump's control or are they under Gavin Newsom's control? But obviously, the California National Guard is going to be going out there and doing this. That's what he seems to be believing is the reality here. And that's such a ridiculously pie-in-the-sky perspective as to what Gavin Newsom is going to do. Because if Gavin Newsom was going to do that, he would have called them in. He would have called them in. We would have been waiting for Trump to be activating them. He would be activating them. And he didn't. So why on earth would you think they're going to be helping protect ICE? It's such a ridiculous perspective that it just made me feel like, okay, this guy is really nice and fun and enjoyable as far as talking about theoretical law, but he should not be a judge because he clearly has no clue what the heck is happening. He could be a phenomenal law professor, but he should not be a judge. I understand he's Chief Justice Stephen Breyer's brother. I'm sorry, that's ridiculous. You're living in such a Lululand that he's like, obviously no one wants to see ICE agents get hurt. Oh, really? Really? Have you listened to the damn rhetoric from Gavin Newsom and Karen Bass saying, keep protesting. Nothing to see here. Everything's fine. They set this whole scenario up. It's like so stupid. So stupid. It's aggravating. Those are my thoughts on it. I don't think he's a stupid man. I think he's so hopelessly naive that that it makes him sound like a doofus. I think he's an intelligent guy. I think he's a very intelligent guy who's so naive that he expresses commentary that makes him sound like he's just like he's on acid. They should take care stance Gavin Newsom's only ministerial as it's said to pass through him, but not give Newsom ability to veto or not follow through. They did say that. Easy solution, Trump issues the order. That was another question is, okay, so let's say he say that this failed. The nature of the order that Breyer could issue could be like, you're prohibited from ever using them or something like that, or they're now taken away from you. Okay, and then 10 minutes later, Trump can issue a new order. That's what's going to happen. And it seems like that's what Breyer is contemplating here, which just makes it also a joke and ridiculous. It makes it's unfortunate that he seems like an intelligent man who's making his own rulings and perspectives sound like a joke. And that's what happens when you're so open-minded that your brains are falling out. There is no consideration found in the statute. Well, that's part of the problem. Congress gave authority and his ability to remove it and impeach judges are not to answer political questions. I preach and inquire on that. Chain of command. They should have compared this to sending the National Guard to Alabama to integrate schools. Governor has nothing to say. They should have. I agree with you on that. Kimmy Hunt, the protests this weekend are no king. What a narrative coincidence. Felix De La Cruz says 10 U.S. Code, subtitle E, Chapter 1011, Part 1, National Guard Bureau. Read U.S. Code Title 10, Armed Forces, the Trump's California law. That's what they were talking about. That's what we're fixating on the entire time, brother. It's not reasonable. Congress gave POTUS that authority. Congress can check POTUS. Well, I thought that was an interesting argument that counsel for Newsom made, which is he doesn't have a right to order troops. He just has a right to what to do with them once they are ordered. And it's not fundamental power of his to call forth the military. Just he's commander in chief of what military is given to him. But Congress is the one who gives him the military. Which I thought that's a pretty powerful argument. It's true. It's true. And it does sort of keep the checks and balances and keep someone from becoming a king. I don't want to deal with just this scenario. I want to deal with all scenarios going forward 100 years after I'm no longer on this earth. So it was a little hard to follow. I read Margaret Cleveland's live post, helped to follow. Having text to read along would have helped. Thank you for doing this. I tried figuring out how to have that. I tried figuring that out. I couldn't. I don't think it's about the 3 question. It's about the answer needs to be met, and does a judge can decide. Judges aren't elected. I know, but I do think that's a fair assessment. Try to figure out who does make that call. Who does make that call? And what deference should be given to the president in this scenario? I think it's an interesting legal philosophical question. Because you would think it should be the president's call. If not his call, whose is it? Someone's got to make the determination. Someone's got to claim it. And he's obviously the most logical person to be making the claim. To be making a claim that, oh, there's a rebellion. I mean, who the hell else would be making that claim? We have to wait for Congress to get together and decide that there's a rebellion? That sounds pretty stupid. That sounds about as efficient as the Communist Party or the DNC, which are nearly indistinguishable. All right, that's what I got for you. I'm wrapping up over here. I thank you so much for joining me. I plan on streaming tonight at 10 o'clock. I hope to see you all then. Till next time, till later today. Take care of yourselves and Godspeed.